Hello friends, Namaskaram, how are you? Myself is Dr. Jineesh Soni. I am an advocate and a defense counsel. Har Har Mahadev, Jai Shiv Shambhu, Jai Mata Di. In today's class, we will discuss a mood problem. The problem is, suppose you are a YouTuber or a content creator. You inter alia upload certain post on the YouTube or on the Facebook. And there is an objection by the third party or by any other person that by your content the concerned person or his community had been defamed, or there is a possibility of promotion of enmity, or there is any insult, or there is public mischief, or there is threat to public order. In that scenario, you might be implicated as per the protocol of section 353 of BNS. And apart from that, the provisions of IT Act could be attracted or could be erred. In that scenario, what we can do, what solution we are having as per law. So I will discuss each and everything, and I will specify you the recent judgment of Honorable Supreme Court wherein a great relief had been inclined to the innocent accused. So what is the legal position, and if there is anything against you, then how you could contest. So I am going to specify each and everything on the board. Please observe the things first, then make yourself conceptually clear and then note down the same so that you could maintain your record. And then we have to analyze the facts in the light of law, and if it is evident that we are having a proper solution in the light of law, then we may approach to the Honorable High Court or to the Honorable Supreme Court to vindicate our grievances. First of all, we have to note down certain important points. Judgment is pronounced by Honorable Supreme Court of India. Number 2, it is dated 2nd Feb 2026. In that case, Honorable High Court had quashed the FIR and state had moved before Honorable Apex Court, and finally the petitions had been dismissed by Honorable Apex Court. In that case, the FIR has been registered regarding the political issues. The contention of complainant was that due to the content of the concerned YouTuber, there is a case of defamation, and apart from that, the community had been insulted. Everything has been done by the accused with intention, and the same resulted a crime as per the protocol of section 353 of BNS. While questioning the entire case, Honorable High Court had propounded certain guidelines which are approved by Honorable Supreme Court. The guidelines are: number 1, before registration of the case, the concerned police is bound to verify who is going to lodge the FIR. The person must have interest in the case. If there is no locus standi and he is a third party, he should not be entertained. It is specified by Honorable High Court and upheld by Honorable Supreme Court. Please note down it. Number 1. So basically we have to observe even in our FIR who has lodged it. Please note down same. In our FIR, we have to specify who has lodged it. If you find that it is lodged by a third party, he is not having any interest in the matter, it is just for the popularity or just to extort the money, in that scenario, we could make the objection before the police as well. Now, I am coming on point number 2, that says that the preliminary inquiry is bound to be held by the concerned police to ascertain the fact. And apart from that, section 173 subclause 3 of BNSS also mandates the same. If there is no preliminary inquiry and directly the FIR has been registered, it is abuse of process. In that scenario, we could make the objection, but regarding this, Just observe your FIR. If there is any allegation that defamation had been occurred, in that scenario, FIR could not be registered. The course is that the complainant should file a complaint before the court, and court has to adopt the process that is laid down as per section 174, subclause 2 of BNSS. Please note on the same. Number 4, the FIR could not be in the mechanical way. If it is in the mechanical way, we could make the objection. Now the important question arises, how we could say that FIR is mechanical? If there is no allegation specification, if there is no evidence on record, in that scenario, we could say that the FIR is mechanical. And that's why the option of inquiry is given to the concerned police before lodging the FIR. In addition to this, in such FIR, the arrest could not be done in the automatic way, or in the routine way, or in the mechanical way. As observed by Honorable Apex Court, by relying on the guidelines of Honorable Apex Court, that is 2014, Volume 8, SCC, page number 273. In simple words, we could say that the authorities are bound to follow the mandate of Section 41A of CrPC or Section 35 subclause 3 of BNSS, and apart from that, they are bound to follow the guidelines of Honorable Supreme Court judgment, that is Arnesh versus State of Bihar. Judgment date is 2nd of July 2014. And apart from that, the concerned authority are bound to take legal opinion from the public prosecutor to proceed, not to proceed. In addition to this, the authority has to find out whether there is any promotion of enmity, whether there is any intentional insult, or whether there is any public mischief, and how the public order has been affected. So simply we could say that a threat to the public order. So if the specifications are not there, FIR is in general way, the allegations are general, there is no specification, there is no evidence, in that scenario we could say that the proceedings are abuse of process. So simply whenever you are going to observe the things, just make the objection so that we could be succeeded in our case. So I think that I have specified you the things in the easier way. Whenever there is any FIR concerning any allegation, as I specified to you, there is no need to be in panic or anxiety. Just observe the FIR, submit your objection. If the concerned submissions are not going to be considered by the concerned authority, in that scenario, we may make our objection before Honorable High Court. As per the protocol of section 528 of BNSS, in that scenario, we could be succeeded and we could protect our life and liberty from being compressed. See you in the next lecture.